The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. We are here this morning for 2 oral arguments, and 1 case will be submitted without oral argument. The first case is Mlady versus Dougan. Second case is Hills and Dales versus Iowa Department of Education and AEA. And the third case is submitted at this time without oral argument, State versus Jackson Douglas. So we'll begin with the Mlady case. Ms. Wickham, I believe, is going to be presenting for the appellant. Thank you. You may begin. Oh, excuse me. Yes, it will be Duffy. I have my notes wrong. I'm so sorry. Yeah, we're going to shake it up a bit today. No, go ahead.
May it please the court and Attorney Hartman. It's a privilege for me to appear before this court today. I'm John Duffy. I started representing Sue Dougan, the redeemer in this case, about 3.5 years ago. She's attempting to redeem a 208-acre farm in Howard County, Iowa, from a foreclosure sale that occurred on May 22, 2017, to Wayne Mlady. Mr. Mlady paid $1,600,001 for the property. So on March 30, 2018, Sue Dougan paid the clerk of court of Howard County $1,690,000 to redeem. The foreclosure sale was based upon 2 promissory notes, and each promissory note had provided for 2 rates of interest, a default rate of interest and a base rate of interest. So Sue Ann Dougan, realizing the dilemma, immediately, very first thing, a couple days later on April 2, 2018, she filed her petition for safe harbor under section 628.21 of the Iowa Code. That petition said, court, please tell me what the applicable contract rate is to compute the necessary amount to redeem. Which rate should be applied? And she asked the court to make that determination. She filed with that her affidavit of redemption, stating that she believed that the base rate of 4.25% applied. And with that, she also filed the assignment from Conrad Clement to her of his right to redeem and her acceptance of that assignment. And then she also filed with that a brief in support of her petition requesting safe harbor relief, which recited the only 2 applicable Supreme Court cases that have dealt with this issue. Waterloo Savings Bank v. Carpenter in 1943, Federal Land Bank versus Bryant in 1989. And both those cases basically decided that the statute which dealt with redemption and required payment of the purchase price stated in the certificate of purchase plus interest at the contract rate also applied to or adopted the reference to the interest rate in the notes. So the question that Sue Ann Dougan presented to the district court back on April 2, 2018 is the same question she's asking the court today.
If that question had been answered at the outset in response to your petition, would we need to be here? Would this case have needed several appeals? And you were thrown for a loop because the court initially erroneously held the assignment wasn't valid. But here we are in the
25. It's the statute is very clear.
But why doesn't the default interest rate control? Because Mr. Clement was in default and you're stepping into his shoes, or Ms. Dougan is. So why not 21% instead of 4.25?
the Dougan referred the district, or at least the Court of Appeals, to the case called Royal Manor. It's a Sixth Circuit Court of Appeals 2015 decision in Michigan. And basically, the basic argument is the sale on May 22, 2015, paid off the default.
Counsel,
On.
but weren't the terms in that note different? If I recall right, in that case, the default rate only applied as long as it was unpaid, the balance due was unpaid for a period of 30 days. So they looked at the specific terms of the note, and what are the terms in the notes that are applicable here as far as the default rate? Does it ever revert back to the base rate?
Not to my knowledge, Your Honor. I think that the two notes that Great Western Bank was using are similar notes to those used by banks today. There's a default rate and there's a base rate. And if there's a default rate applies. Now, these notes were a little unusual because it went from 4.25% to 21%. The Zylstra case, which we may want to talk about, dealt with a 2% swing. So the swing here monetarily is substantial. It's over $270,000.
Kate, what your client provided for this assignment or how your client obtained this assignment?
Testimony in the district court. There was a deal between Clement and Dougan. Dougan loaned money. The redemption, basically, because there was this deficiency judgment of over $250,000, Clement couldn't redeem. The law would say that deficiency judgment would be imposed as a lien against the real estate. So he assigned his right to redeem to Dougan, and she had made a deal with him to loan him money, and this redemption was a way for her to sell the farm and get some money back and make a deal. This is the Iowa economy at work.
It is the Iowa economy at work, so why don't we just follow the literal terms of the documents?
And yes, and that's what we're asking for. We have no trouble with a note that has a default rate and a base rate, but Dougan should be entitled to redeem at the 4.25% rate. And I haven't yet answered the judge's question of why 4.25%, because there's no default. Once the sale occurs, there's no default. The district court, the Court of Appeals, the amicus curiae brief also said
There's a default originally, and I don't see any language in the contract that would reset the amount back down to 4.25.
except only that let's take a look at the fact that the default was paid. Let's take a look at the title of Chapter 628, its redemption. Let's take a look at what the statutes provide, and that is 628.3 says the debtor has the right to redeem, in this case, an exclusive right to redeem for a full year. Secondly, under 628.25, there is the right to assign that right to redeem. And so there's a statutory policy encouraging the debtor to redeem, to buy back his farm. If there's a statutory policy that encourages the buyback or the redemption, why impose a default rate? I think the court has a choice between 4.25% and 21%.
The amicus brief by the Iowa Banking Association that this would, if we went with the lower rate, it would drive up costs of lending in Iowa. It would create.
That brief did not explain that. It says, hey, we got to charge a default rate to encourage bidders at a foreclosure sale. Look at the facts of this case. Up on appeal, 21%. Back down to district court for consideration. District court says 21%. Why? Because the notice of levy says 21%. Well, that's the sale. That's before the sale. After the sale occurs, the certificate of purchase takes its place as a piece of paper, doesn't state a rate of interest on it. And so the question is, what's the rate of interest post-sale, post-default? And I think it's important maybe that
Have a per diem interest amount on it?
being judged the certificate of purchase. No, there's no reference on the certificate. The certificate of purchase is handed to the bidder at the successful bidder at the sale. It's a piece of paper. It takes the place of the note, takes the place of the mortgage, takes the place of the real estate. It says Mlady purchased the real estate on May 22, 2017. The issue is, what's the rate of interest on that certificate from May 22, 2017 for the succeeding year to May 22, 2018, the one-year period of redemption? No statement of interest on the certificate of purchase. And let me also point to the court, this citation, Counsel v. McCumber, 1925 case, but it's very apropos to this discussion. It says, quote, "The right to have the security foreclosed in the method provided by statute and the right to the period allowed by law for redemption are a part of those humane provisions established by law for the protection of improvidence." That's a noun. Clement is an improvident. He couldn't pay his bill. The policy is to promote the redemption by an improvident, and the unfortunate and their helpless.
You know, that is the stated policy, but once you're talking about an assignment, sort of a commercial transaction between the debtor and somebody else, why do we favor one party that made a commercial transaction with the debtor over the bank, which is the other party?
Policy speak to that?
And that seems to me, it doesn't make any sense. It does seem to me that if you told me, if there's a property I was interested in and you told me I can go bid at an auction for it, but if I happen to buy it, anybody after that in the next year that happens to come along and make the right kind of deal can buy it back from me for whatever I paid plus 4% a year, I wouldn't be very interested in buying it. And if you chill, foreclosure sales, then what you're going to end up doing is drive up the cost of borrowing. I mean, it's a commercial transaction, right?
Commercial transaction, but judges, I ask you, going back to the first question, if Dougan would have been afforded the right to redeem on April 2, 2018, would she have paid the full amount? She would have. And in deciding today what rate should apply, why would the court impose a mandated interest rate on the $1,600,001 certificate of purchase if it would require a default rate? It would require the purchaser to pay interest at a default rate upon the default rate included and computed in the purchase price. That $1,600,001 was a default judgment. It computed accrued interest at 21%. Why would the Supreme Court want the redeeming public to be required to pay default interest to buy back a farm that already included default interest when the default was gone? The marketplace should prevail. The marketplace should allow the redeemer to borrow money at whatever rate is available, not a mandated default rate.
On Justice Mansfield's question, don't we want to incentivize people like the Mladys to come in because they're more likely to pay to buy foreclosed property if they're going to be rewarded for that one-year holding period at a higher interest rate?
And that argument was made in the amicus curiae brief. Again, up on appeal, 21%, down 21%. The district court said 21%. And what happened to that ruling of the district court? Mlady appealed. Mlady appealed. He could have taken the he was buying the farm. He wasn't buying a certificate at 21%.
Let's shift to the other issue. If hypothetically we affirm the 21% interest rate, then you're about $1,800 short of the
$89.79.
that you know, and except for horseshoes and hand grenades, close doesn't count. I mean, what if you? I mean, if you fall short, whose problem is it?
In this case, where Sue Dougan applied for safe harbor relief and her petition was not ruled on by mistake, and over a year later, the court on remand finally ruled, September 28, 2019, what the exact amount to redeem was at the 21%. She paid the additional $1,789. Tharp v. Kerr says equity will prevail to prevent a bar to redemption. And I'm sorry, I'm close. I just want to say that Tharp v. Kerr governs, and the Zilstra case speaks loudly. It says, in order to grant equity, let's look at the entire record. And if there's a reason to provide equity, we should provide equity to allow for redemption under Olson v. Siebert that favors redemption, the statutory policy, the public policy. In this case, she applied, court denied.
The payoff amount,
District court,
$100 short. I thought that amount was determined by somebody retained by Ms. Dougan. Is that correct?
it's computed, that number first arose in the first appeal in the brief of Mlady. And then it got incorporated in the decision of the district court on remand. And the precise amount of $1,938,000 some odd dollars included that $1,789.89. So in recognition of that shortage, Dougan immediately paid that on October 9.
Tendered. Who told her to pay that amount?
The district court, because the district court on remand said the amount was $1,900,000 and some odd dollars, and she realized that was short one. So the district court finally ruled on her petition post-appeal. And Zilstra says, look on the record. If there's nothing else that allows equity, she doesn't get equity. But here she had applied to the court, been denied the right to redeem, had not got a ruling on her petition that she filed well before the running of the period of redemption on May 22, 2018, and been denied that legally by that mistaken district court decision. So whose mistake? Where's the premium here?
That statement, and it'll be the other person.
I'm on this mistake. Not Sue Ann Dougan. It would be Mr. Mlady. Mr. Mlady has been in possession of the farm since 2017, 2018, 2019, 2020, 2021.
Why don't we let Ms. Wickham go? Thank you.
May it please the court, counsel. My name is Lynn Hartman, and I'm here before you to speak on behalf of my client, Wayne Mlady, who is a local farmer in the Cresco, Iowa area with no connection to Conrad Clemens. And he bought this property with the understanding that he would within 1 year, get title to the property, or he would get his money back at the default interest rate, which was clearly set out in the judgment and the sheriff notice, which were the only documents that were available to him prior to bidding at this sheriff's sale. The equities in this case are for my client, Mr. Mlady. One thing I want to clarify on the record is the argument and the statements that counsel made regarding who calculated the amount that was supposed to be set out as far as the interest was concerned. Ms. Dougan was represented by two attorneys, Mr. Duffy, and then she also had an attorney, Mr. Swain, who was from Minnesota. She testified under oath, and it's cited in our brief, and I can point you to the exact record, but she cited that her attorneys had made that calculation, and she acknowledged and admitted that the attorney's calculation was short approximately $1,800. So it was the default of Ms. Dougan that caused the...
Follow-up, counsel had just stated that that number came from the district court when I asked the same question about who calculated the amount that ultimately ended up being short. My understanding from the record is she testified, Dougan, that her attorneys calculated that amount. But is there something in the district court record that set forth the amount that was in accord with the lawyer's calculation?
That what happened at the district court level was that at the hearing, it was admitted that the calculation was $1,800 short based on the contract rate and the 21%. So there was no finding by the district court prior to the ruling in July of 2019, which indicated that it was short. The court, yes.
Are you talking about the first district court proceeding, or this before in 2018, or the one in 2019 on remand?
2019. The issue in 2018, there was no finding about the amount that was owed. It was in 2019 at the time that was when the court made a record that it was short. There was nothing that Ms. Dougan relied on from the court to put that amount out. She made her own calculation.
I mean, is it close enough, though? Is 1,800 enough to defeat the purchase of a property of 1.9 million, roughly?
If we follow that precedent, it's basically overturning 148 years of precedent. This court has not ever, the only time that it has ever allowed equity to prevail is because there was a mistake by the clerk. And the Tharp case is very clear. It indicates that if there is default or neglect, this court should not award equity. And in this case, it was clear that there was default and neglect. Ms. Dougan is a sophisticated businesswoman. She owns hundreds, or yes.
So is part of the reason that it comes up timing-wise, though, is because the district court originally concluded that the assignment was bad. And so if the district court originally, what was that, in April of 25, instead of saying the assignment was bad, had upheld the assignment and then determined the proper amount of interest rate at that time, is the record clear that she would have then made had deposited the right amount within the 1-year period?
No, Your Honor. I mean, and the case law is clear that it needs to be deposited before the 1-year redemption. And if you look at it, I'm sorry, go ahead.
On April 25th, which was still within the 1-year time period. So at that point, the district court didn't even address the interest rate amount because the court said the assignment was no good and Ms. Dougan wasn't entitled to redeem at all. And so then it had to go up on appeal and then come back. And it was when it came back on remand then when the district court said, okay, so the Court of Appeals has corrected, Ms. Dougan can redeem. The correct amount is the 21%, and here's your amount. If the district court would have said that on April 25th, 2018, that would have still been within the redemption time.
Correct, but I don't know that the court would have made that calculation. I mean, the court may have said, yes, 21% applies, but still, Ms. Dougan's attorneys would have had to calculate that. I don't see the court, in the cases that I deal with here, actually make the calculation. They just say, the contract rate is 21%, and you should apply the contract rate. And she had 2 attorneys that needed to do that. And the equities in this court really are for my client, Wayne Mlady, who, you know, he has put the money down. It's been 4.5 years that he has sat by and not known whether he has good title, has not had his use of the money. And instead, he has to come up and, you know, based on the timing that we've had on this, which has been so bad because all of these rulings have been in the end of May, he has been having to make a determination each planting season whether he can go ahead and plant or not. And that's why in 2019, he entered into an agreement to pay rent just for that year so that he could have some certainty. But the whole purpose behind the redemption statute and the legislative intent, and I think if you look at the a case that the court decided, I think in 1968, that set out the legislative intent, it is clear that 1 year is the longest that it can be. I mean, Iowa's redemption statute is one of the most liberal in the country. And if this court is going to, based on these equities, extend that, we're going to have the problems that we have in this case. Mr. Mlady is looking at a 5th planting season without having his money and without knowing whether he has full title. And if the court enters into and does not uphold the Court of Appeals but does what Ms. Dougan asked, he's going to be faced with more litigation, because then she's going to say, well, I had proper title to the land and you were using that land for these years, and so I want rent back. And so once again, we're going to be at the district court, and maybe 1 year from now or 2 years from now, we're going to be back here on the issue of what was the proper amount of rent, or should rent be paid when it's done. So
Hard to talk about Ms. Dougan's sophistication as an investor. Could you elaborate?
the record is clear that she, in this case, had no ties to this land. She was a creditor of Mr. Conrad Clement, who was a very sophisticated businessman who owned Featherlight Manufacturing. He owed her $600,000, had owed her $600,000. I think the record was for at least 10 years, maybe even longer. And she saw this as her way to get back some of that money. And the thing that I think is even more egregious and why the equities in this case don't apply to her is she waited till the 11th hour to take this assignment and to approach this court and ask for clarification on this. And in this case, the court ruled pretty quickly. I mean, if you would look at the court's ruling in 2019 when this came back down and the issue of the interest rate and those things, that was 58 days. And if the court would have ruled at that time, we would have been out of the redemption period. So, you know, my client was sitting there, you know, thinking that he's going to have title to the land, and then, you know, less than a month and a half before, he is faced with this novel issue. And so
Follow up on one of Justice Oxley's questions. We have some older cases where the clerk gave the redeemer the wrong amount, and in equity we excused, you know, underpayment or delay. Does the court's failure to rule on the interest rate in this case, or its erroneous ruling about the validity of the assignment, bring us within that line of, you know, cases where you could get equitable relief?
Your Honor, I mean, the cases are clear that you really want to limit the situations where you're going to apply equity and do this. In this case, Ms. Dougan had 2 attorneys representing her, and she came here at the 11th hour. And if, in fact, we say an erroneous court ruling is a reason to allow her equity, that's going to expand the equitable argument, and that's not the history of this court. That's not what the legislative intent is. Yes?
How should things have happened under 62821 when Ms. Dougan, almost probably a month and a half, say, before the redemption period was done, went to the court and said, please tell me what the correct interest rate was, and the district court didn't rule on that issue at all, and it had to go up on appeal and come back. So what's the purpose of that statute, the 628.21 safe harbor rule, in this respect when she did go to the court and ask for the interest rate?
Purpose behind that, and I think if you look at the legislative intent, it was there to provide more certainty, and the cases are very clear that just because you take advantage of that safe harbor, that you aren't still required to provide the proper amount of funds for that redemption. Because if in fact if that's not the holding, then you can have a situation where someone's trying to game the system. I mean, in these situations, when someone's trying to redeem, many times they're cash short. So if in fact they decide that they're going to put the lower rate and not use the default rate, I mean, in this case, that would be $250,000 a year. And we're now sitting here 4.5 years later, and we're over $1 million that they would have been able to say, well, based on the safe harbor, because I used the safe harbor, I didn't have to put that money there. I mean, the cases are very clear that the Redeemer needs to take the initiative, and they need to put the proper amount of money with the clerk. And at that point, if in fact the ruling is made against them, then they will get a return of that. But the statute is very clear, and the case law is clear as well.
Appeals in this Zalats, or however you pronounce it, say the burden is on the Redeemer to figure out the right amount, make sure it gets paid on time.
In the Zylstra case, they said, even in that case, they did not put the interest in with the clerk, and it didn't indicate that. But the court in that case said, even if they had, they needed to put the proper amount. And so, the Zylstra case is just a good example of where the statutory process of redemption cannot be a guessing game for the certificate holder. And if, in fact, we do what Ms. Dougan is asking, it will be such. And, Your Honor, I want to go ahead.
That the partial, her first payment should have lowered the, by paying some of the principal into the court, should have lowered the per diem interest rate going forward, or is that argument foreclosed by the, 1943 Waterloo decision?
That exactly is foreclosed on that. And I mean, the case law is very clear that, the amount that is set out in the judgment, and in this case, the amount was 21%, and that is the amount that needs to be paid, and it needs to be paid in 1 year, and it was not in this case. I wanted to also just point the court to the case that I was referring to, which is Farmer State Savings Bank and Manning, and I think that puts a really good synopsis of what the legislative history and the court's need for, redemption rights to remain in 1 year. The other point that I'd like to make, and this will be the last one, is that, the legislature, that case is really good to show what the legislative intent is, and that is to limit redemption. And since that time, we have seen the legislature limit redemption in residential and non-ag situations. And so for the court to rule as Ms. Dougan is requesting would be contrary to legislative intent. Thank you, Your Honor.
Mr. Duffy?
The computation of the $1,798.79 is in a footnote of the brief of Mlady, and it's in a footnote of the first ruling. That's the first time it showed up. Dougan did not compute that. Dougan, with her petition, asked actually for a refund, asked for a computation of the 4.25% rate, not the 21% rate. Her position was 4.25%, and she paid $1,690,000, knowing she overpaid, asked for the computation, and believes she was entitled to a refund under 62820 of something like $68,000. That was her computation. She never computed the that shortage. That was done on appeal.
In the original one-year redemption period, the court did not give her the wrong number.
Correct. The court never ruled. And that's why this is a unique, excuse me.
Question, would it be fair to describe her as a sophisticated investor?
As to whether or not she's a sophisticated investor or not, I don't know. She was interested in buying this farm as an investment. That's true. Zylstra. This case is one of a kind. No other case. We mentioned the line of cases about the clerk's mistake, Kunch, Hansen, Fry, Graves. Zylstra said no redemption. Why? Because the redeemer didn't pay interest on the purchase price. And so here's the district court, here's the Court of Appeals looking at that and say, is there anything in the record that allows us to give equity as provided in Thorpe v. Kerr? We don't want to provide a premium for neglect, but, and specifically, what did the court say? This record is devoid of the redeemer asking for safe harbor relief. This case is unique in the sense that Dougan was not a cheater. She was not trying to get by without paying the full amount. All she ever wanted to do was to pay the amount necessary to redeem, and she asked the court to rule on it, but she was deprived of that right during the redemption period. And not until after the one-year period lapsed, and the district court ruled on remand on September 28, 2019, was she told the amount necessary to redeem was $1,938,799.79, which would have included that additional shortage. And then she paid the shortage. She didn't.
In April of 2018, at the time that the district court said you don't have the right to redeem, and Ms. Dougan appealed, at that time, she's the one that determined how much extra to pay in just in case. And that's the amount that was $1,800 short.
$147,001, computing the interest at 15% on a 365-day basis instead of 360. But the court had not ruled on that. We took a chance. We paid that provisionally.
And then to follow up, on the safe harbor statute says that the person claiming the right may deposit the necessary amount. And so what is your response to your opposing counsel's argument that you still, even with the safe harbor, it was still your client's obligation to pay the necessary amount to take advantage of that safe harbor?
I would agree with that language. The facts of this case, though, are very unusual in that she did apply for safe harbor. She did try to apply it, and in no other of this line of cases.
For the one that told her to pay $247,000 based on a 360-day rather than 365-day, why didn't you do the 365-day rate? Okay, and who's in the law, in an area of the law that requires certainty and predictability and clarity, where should the burden of the risk of loss or a mistake fall?
By a mistake, if that you don't pay a premium for that mistake. Where's the premium here for this mistake? Where the court deprived her of the right to have a ruling before the period of redemption expired. No other case.
The pitfalls that were discussed by opposing counsel regarding future litigation, if it's resolved the way you're requesting.
I think the court, if the court were to say 4.25%, it would clarify the marketplace. How are we going to promote litigation if we have imposed a 21% and apply equity to allow her to have paid that additional $1,000?
On a claim for rent for those years that she didn't have it.
The opposing counsel said Mlady has got a problem here. But Mlady has been in possession of the real estate. She's talking about Mlady getting paid. Dougan is the one that has deposited the full $1,938,000, not Mlady. Mlady won't get the money back. He'll get the farm.
Thank you. The case of Mlady versus Dougan is hereby submitted. And while we have a transition of attorneys, we will get ready for the case of Hills and Dales versus Iowa Department of Education.